Washington, April 13. The U.S. Supreme Court refused on Thursday to stop a legal settlement that would wipe out more than $6 billion in debt owed by former students of colleges, most of them for-profit institutions, saying they were misled by academics and schools about job prospects. The judges turned down a request from 3 colleges that contested an agreement between the U.S. Department of Education and borrowers linking the colleges to allegations of significant misconduct, which they disputed. 3 of schools mentioned in deal, the for-profit Lincoln Educational Services Corp and American National University Inc., and non-profit Everglades College Inc., opposed deal after it was upheld by a federal judge in California last November. Nearly 3,500 borrowers eligible for automatic loan discharge under the agreement attended one of 3 schools. The decision was separate from a pending lawsuit in the Supreme Court over the legality of President Joe Biden's plan to cancel $430 billion in student debt for nearly 40 million borrowers. A decision in this case is expected by the end of June. The latest dispute arose from a class action settlement where the Department of Education would automatically cancel the debt of approximately 200,000 debtors who went to 151 schools. Schools are accused of increasing enrollment through aggressive sales tactics, as well as misrepresentations about the quality of their academic offerings, graduate career prospects and networking opportunities, according to Eileen Connor, litigation director for a group, the Predatory Student Lending Project. The swift and determined action of the highest court today should definitively end any ongoing debate about the legitimacy of this agreement. The 3 schools argued in court filings that their reputations were damaged by comparing their inclusion in the settlement school list to A, being branded with a red letter. They also argued that Biden administration did not have the legal authority to cancel debt. The settlement originally stemmed from a legal effort by borrowers in 2019 to force the then-Minister Education Betsy DeVos, who served under President Donald Trump, to reconsider the Department of Education's judgment on allegations misconduct against schools. After 3 years of litigation and a change in presidential administrations, the parties reached an agreement in June 2022. In March, San Francisco-based 9th U.S. Court of Appeals rejected a proposal to block the settlement from going into effect while 3 schools' appeals process was pending. 20 conservative-leaning U.S.